Your Honor. However, again, the nature of this discrimination makes it virtually impossible to compile massive evidence.
But that's the point I think that we're all making, that I think Judge Gleason might have said this, it's hard to prove. Doesn't mean that you don't have to provide proof. And you know, I think as Judge Schindler indicated, you know, we see in some of the materials that literally it's just 1% of these applications that are not granted, and what part of those are mainstream, what one would consider mainstream religions versus less mainstream. I think, you know, you've got a tough road to hoe here. You've got to really be able to demonstrate that there is proof of, again, widespread violations. And you know, this is something that you cannot get action under the 14th Amendment unless you've made that proof. But anyway, continue with your argument, but that certainly is central to have a factual foundation.
Yes, Your Honor. With my remaining moments, I'd like to move to the Establishment Clause issue. And our LUPA is constitutional under the Establishment Clause for two reasons. First, our LUPA satisfies all three prongs of the test set forth by this court in Lemon versus Kurtzman.
Go through each of the three prongs and tell us.
Yes, Your Honor. The first prong is that a statute must serve a secular purpose. And it is well settled that when a statute seeks to eliminate discrimination or accommodate the needs of religious groups, that it is a secular purpose. And to be sure, this court has never struck down a statute as not having a secular purpose. With respect to the second prong, our LUPA does not advance religion. Our LUPA seeks to even the playing fields and eliminate discrimination. And this court held incorporation of presiding bishop versus Amos.
Does it even the playing field or provide a better playing field for religious groups with a special forum as opposed to others? So is it even, or is it providing, again, a special, greater benefit?
It is evening the playing field, Your Honor, because there has been evidence of discrimination, and it provides a remedy. And this court stated in Amos that accommodating the needs of religious groups and acknowledging the right to worship does not amount to an advancement of religion. And in cases where courts have found that a particular statute advances religion, those cases involve government action where the government itself advances religion. And here, our LUPA seeks to limit government action.
But of course, as Justice Stevens said in the Bernie case, the religious institutions have a right that no agnostic has. I think that was his quote. Namely, you get to come to federal court, but everybody else has to have an Article 78 proceeding. Why this special right?
Because, Your Honor, religious groups are practicing a fundamental right to practice their religion through the First Amendment of the Constitution. Your Honor, I see my time has expired.
Can I just ask one more question? Would that be
sure, of course.
What is there really a substantial burden here? What is the substantial burden on the institution?
On these particular facts, Your Honor?
Yeah.
Your Honor, as the record indicates, the school needed additional space. They offered building plans. The subcommittee that scrutinized the plans unanimously voted to approve the special permit. And then after the controversy that was related to polygamy ensued, the zoning board unanimously reversed their decision and refused to allow them to build.
Can I ask one?
Well, it's a non-religious school.
Go ahead, Judge.
It's okay, Cheryl works. In fact, wouldn't a non-religious school be at a disadvantage in this particular case?
Yes, Your Honor. A non-religious school would not be able to obtain relief under our LUPA because our LUPA does protect the free exercise of religion.
Counsel, get to the third prong. How is this not entanglement?
Your Honor, the entanglement prong contemplates government oversight or supervision of religious activity, and in no way whatsoever does our LUPA foster government entanglement.
Well, the government's got to decide whether this is a bona fide religion or whether this is a religious dispute in the first instance. So isn't that a prima facie entanglement issue?
Your Honor is correct that the zoning board will have to determine whether it's religious exercise. However, governmental actors always have to take into consideration whether their actions will create an unconstitutional burden on an individual in society.
Well, since you concede that a non-religious school would have an advantage, doesn't that advance religion?
No, Your Honor, because Congress has found that it was necessary to enact legislation to protect the guarantees of the 14th Amendment, namely the Free Exercise Clause, by protecting religious institutions.
Thank you.
Thank you.
May it please the Court, I am Betsy Gates from Team 17, and I represent the petitioner Cormac T. in this matter. Your Honor, under the Individuals with Disabilities Education Act, or IDEA, if a public school district fails to provide an appropriate education to a special needs child, the district must bear the cost of that child's private school tuition. This Court should not read...
But if a child doesn't offer him or herself to be educated in the school district, how can the school district be said to have failed to educate him? I don't understand that.
Your Honor, in this case...
This kid wasn't even going to the public school.
Your Honor, in this case...
So we don't know whether the IEP was adequate or appropriate. We don't know whether the student was making any kind of meaningful progress because he was someplace else.
Your Honor is correct that the petitioner's son, George, was educated during his preschool years at a private school. However, the record on page 2 reflects, 2 and 3, that his parents moved to Santa Teresa partly because they heard the public schools there were very good and wanted to enroll their child there. They contacted the school board not once, but twice, requesting an evaluation for their child, which they ultimately received, and an IEP was prepared, which is a very extensive explanation of the services that the school district offered. The petitioner felt that these services were inadequate to meet his son's needs.
No, that's not entirely right. The IEP was a determination by the specialist at the school as to whether this curricula was reasonably calculated to permit this child to make progress in school. So it was a prediction in many ways of future behavior. So if we do not, if we have no way of determining what the future behavior was, we have no way of determining whether the program was adequate.
Your Honor, the IEP is more than a prediction. It is a program. It is a detailed description of an educational program that details day to day precisely what services are going to be provided.
Does the parent make a unilateral decision that it's not sufficient, it's adequate or not adequate? Is that what happened in this case? Is that the parent's right to say, well, that's not adequate, I'm going to go to the private academy?
Well, Your Honor, of course a parent always can choose to put their child in a private school at their own expense. However, they do
I mean,
bear...
vis-a-vis reimbursement.
Certainly, Your Honor. The parent bears the burden in all cases for tuition reimbursement of proving that the public school's IEP is invalid because it is inappropriate and not reasonably calculated to meet their child's educational needs. The burden is always on the parents to show this proof. And the question before the court in this case is whether the parents even have standing to present that proof.
Well, so the question is, doesn't the plain language of the statute require that the child actually participate in a public education program in order to be eligible for reimbursement?
No, Your Honor, the plain language does not indicate that. There are two provisions of IDEA which are relevant to this court's consideration of tuition reimbursement. The first is Section 1412A10C, which is applicable where a child is being removed from a current public school special education placement. However, the enumeration in the statutory scheme of this one circumstance does not by implication